5 seconds to go. Start. The public servant working in discharge of his duties or purported discharge of his duties, and whether the public servant has exceeded his limit. It is true that section 196 states that no cognizance can be taken, and even after cognizance having been taken, if facts come to light that the acts complained of were done in the discharge of the official duties, then the trial may have to be stayed unless sanction is obtained. But at the same time, it has to be emphasized that criminal trials should not be stayed in all cases at the preliminary stage because that will cause great damage to the evidence. This court in P.K. Pradhan vs. State of Sikkim reported in 2001 6 SCC 704 re-emphasized that for invoking protection under section 197 CRPC, the acts of the accused must be such that it cannot be separated from the discharge of the official duty. However, if there was no reasonable connection between the act and the performance of those duties, and the official status only furnishes the occasion or opportunity for the illegal act, then no sanction would be required. The court acknowledged that the question of sanction can be raised at any time after cognizance, that is, may be immediately after cognizance or framing of charge, or even at the time of conclusion of trial and after conviction as well. However, there may be certain cases where it may not be possible to decide the question of sanction effectively without giving opportunity to the defense to establish that what he did in the discharge of official duty. In such cases, the question of sanction must be left open to be decided in the main judgment, which may be delivered upon conclusion of the trial. The relevant observations are as follows. It is well settled that question of sanction under section 197 of the code can be raised any time after the cognizance, may be immediately after cognizance or framing of charge, or even at the time of conclusion of trial and after conviction as well. But there may be certain cases where it may not be possible to decide the question effectively without giving opportunity to the defense to establish that what he did was in discharge of official duty. In order to come to the conclusion whether claim of the accused that the act that he did was in course of the performance of his duty was a reasonable one and neither pretended nor fanciful, can be examined during the course of trial by giving opportunity to the defense to establish it. In such an eventuality, the question of sanction should be left open to be decided in the main judgment, which may be delivered upon conclusion of the trial. In the present case, the accused is claiming that in awarding contract in his capacity as Secretary, Department of Rural Development, Government of Sikkim, he did not abuse his position as a public servant, and works were awarded in favor of the contractor at a rate permissible under law and not low rates. These facts are required to be established, which can be done at the trial. Therefore, it is not possible to grant any relief to the appellant at this stage. However, we may observe that during the course of trial, the court below shall examine this question afresh and deal with the same in the main judgment in the light of the law laid down in this case, without being prejudiced by any observation in the impugned orders. This court in Devinder Singh vs. State of Punjab reported in 2016-12 SCC 87 had observed that sometimes certain questions about the requirement of sanction cannot be decided without evidence, and questions like the good faith or bad faith of the public servant can be decided on the conclusion of trial. The relevant observations made are reproduced herein below. Question of sanction may arise at any stage of proceedings, on a police or judicial inquiry or in course of evidence during trial. Whether sanction is necessary or not may have to be determined from stage to stage and material brought on record depending upon facts of each case. Question of sanction can be considered at any stage of the proceedings. Necessity for sanction may reveal itself in the course of the progress of the case, and it would be open to the accused to place material during the course of trial for showing what his duty was. The accused has the right to lead evidence in support of his case on merits. In some cases, it may not be possible to decide the question effectively and finally without giving opportunity to the defense to adduce evidence. Question of good faith or bad faith may be decided on conclusion of trial. In the instant cases, the allegation as per the prosecution case is that it was a case of fake encounter or death caused by torture, whereas the defense of the accused person is that it was a case in discharge of official duty, and as the deceased was involved in the terrorist activities and while maintaining law and order, the incident has taken place. The incident was in the course of discharge of official duty. Considering the aforesaid principles, in case the version of the prosecution is found to be correct, there is no requirement of any sanction. However, it would be open to the accused persons to adduce the evidence in defense and to submit such other materials on record indicating that the incident has taken place in discharge of their official duties and the orders passed earlier would not come in the way of the trial court to decide the question afresh in the light of the aforesaid principles from stage to stage, or even at the time of conclusion of the trial, at the time of judgment. As at this stage, it cannot be said which version is correct. The trial court has prima facie to proceed on the basis of the prosecution version and can re-decide the question afresh in case from the evidence adduced by the prosecution or by the accused or in any other manner it comes to the notice of the court that there was a reasonable news of the incident with discharge of official duty. The court shall re-examine the question of sanction and take decision in accordance with law. The trial to proceed on the aforesaid basis. The legal position that emerges from the discussion of the aforesaid case laws is that there might arise situations where the complaint or the police report may not disclose that the act constituting the offence was done or purported to be done in the discharge of official duty. However, the facts subsequently coming to light may establish the necessity for sanction. Therefore, the question whether sanction is required or not is one that may arise at any stage of the proceeding, and it may reveal itself in the course of the progress of the case. There may also be certain cases where it may not be possible to effectively decide the question of sanction without giving an opportunity to the defense to establish that what the public servant did, he did in the discharge of official duty. Stop.